Welcome back. You're watching The Globe on the SABC News Channel. Today, the Constitutional Court handed down a judgment regarding the constitutionality of Section 115 of the Legal Practice Act of 28 of 2014. And this to the extent that it precludes persons who are neither citizens or permanent residents in South Africa from being enrolled as legal practitioners. Now, whether the reservation of the right to freedom of trade to certain citizens as contained in Section 22 of the Constitution infringes on the right to equality as it limits the rights of non-citizens to practice law in the country. And to tell us a little bit more about why this case actually ended up being brought before the courts all the way to the Constitutional Court is the Executive Director of the Asylum Seekers, Refugee and Migrant Coalition. And we're joined by Muchengeti Hwacha, the Executive Director. Thank you so much indeed for joining us. Welcome to the program.
Good evening, Peter. Thank you for having me.
All right. So what inspired this case to go all the way to the Constitutional Court? What was the case before you that caused concern?
Just for background, Peter, there were two sets of applicants, one out of the Bloemfontein High Court, another set of applicants out of the Pretoria High Court. And each one of these applicants had the right to live and work in South Africa, conferred on them by the state. And this is a right that was unqualified, I might add. But they were still barred from being admitted and enrolled as legal practitioners. And just a quick point of correction, Section 24(2)(b) of the Legal Practice Act, read together with Section 115 of the Act. So these two sets of applicants are non-citizens who were conferred these rights by the state, but found themselves limited when they tried to gain admission as legal practitioners.
All right, let's just get some clarity about who can fall in this category. So if you're not a citizen and not a permanent resident, who then can, beyond these two categories, have the right to live and work in South Africa?
That's a broad range of individuals, Peter. There are people who are refugees. There are people who are asylum seekers. Right. There are people here on spousal permits. There are people on work permits. So it actually encompasses a broad range of individuals. However, it's important to note that these broad range of individuals who are under these visa categories are quite limited when it comes to the legal profession. There's only a few, at least from our own analysis, who meet all the requirements to gain admission and enrollment as attorneys or advocates in the Republic.
All right. So what did the Constitutional Court say today?
The Constitutional Court has essentially shut the door on these individuals who are on these other permits, excluding, of course, permanent residents. The court has heavily relied on Section 22 of the Constitution, which confers the right to choose profession on only citizens of South Africa. Now, it's important to note that we, as the coalition and the applicants that came out of the Pretoria High Court, as well as the applicants that came out of the the Bloemfontein High Court, approached the court on the basis of equality and dignity, and not Section 22, which the court sought to rely on so heavily. I would just like to point out that our criticism of the court judgment shouldn't be construed in any way as disrespect or undermining the court. We have the utmost respect in the judiciary and the court system. However, we still think the court got it wrong in relying so heavily on this section and usurping the rights of the applicants to Section 9, which is equality, and Section 10, which is dignity.
All right. So again, to get a bit more clarity, are we saying that there are a certain group of people who are given by the state the right to live and work in South Africa, and they are allowed to work in certain jobs, but it seems this one of being an attorney is one that they can't apply for? So it's okay to work in a bank, it's okay to work somewhere else, but just not as an attorney. Is that what's happened?
That is exactly what has happened. In our analysis, we've only found the legal profession to be the only profession that has this strict bar of permanent residence. All other professions either allow people who have the right to live and work to practice that profession, or in certain circumstances, there are flexibilities that are made to allow persons who are on work permits, spousal permits, and the like to engage in their profession. So the court essentially has relied on what they've called a certainty or fixity in the Republic, to say that our applicants, because they are non-citizens and because they are not permanent residents, they require they lack the required fixity in the Republic to confer upon them the right to be legal practitioners. Now, we firmly disagree. We think that these applicants have, some of them, children in this country, some of them large assets, some of them have been here for a long periods of time, and we essentially still maintain that this gives them sufficient fixity, as the court put it, to found their rights to practice as attorneys or advocates.
All right, so what's your fear in terms of possible consequences about this precedent that's been set?
I think the fear is quite obvious, that this is a bad precedent, that we believe is a bad precedent, and it doesn't bode well for the other professions. This is something that may creep into other professions and affect non-citizens in a broad range of sectors. Above and beyond that, there are especially young people who were born here and likely have lived here their whole lives, not knowing any other jurisdiction, but because they've inherited a refugee permit and or a asylum permit from their parents, they can essentially forget about a career as an attorney or advocate. The one exemption that could have saved this sort of exclusionary provision from being unconstitutional, in our opinion, has been closed on people like our applicants because of a policy of the Department of Home Affairs, which essentially says that if one is seeking to be a permanent resident for the purpose of being a legal practitioner, that policy bars them from applying for permanent residence. So essentially our applicants and people who are similarly situated are locked out of the profession and are relegated really to other smaller jobs, roles in the legal profession, such as legal advisors, etc.
All right, Mr. Hwacha, we're going to have to leave it there. Thank you very, very much indeed for joining us and giving us some insights about your concerns with this Constitutional Court ruling. Thanks for your time.
Thank you, Peter.
All right, that's Muchengeti Hwacha, who's the Executive Director of Asylum Seeker, Refugee and Migrant Coalition. Not happy with the court decision. They said they will abide by it, but they think that perhaps they've got it wrong, because there are a certain category of citizens that are people who are not citizens, don't have permanent residence, but are allowed to live and work in South Africa. And it seems that they may be barred from certain professions in the country. Stay